Hi everyone, I'm Erica from Scout Digital Marketing and I'm here with Paul Gordon from NDA Law today. Thank you very much for joining us, Paul.
An absolute pleasure.
Wonderful. We are here to chat all about GDPR, which comes into effect on the 25th of May, and what implications it has for Australian businesses who aren't actively doing business in the EU, but simply by having an online presence, which is Paul's area of expertise, may be affected by this incoming regulation. Obviously, we don't have very long because it's 23 days to go now, but we're going to chat through. If you do have any questions, please feel free to pop them in the comments. We have Amy Hourigan from Amy Who Digital helping us out today, so she's going to be going through all of your questions and passing them on to us. We do have a bit to get through, but do let us know if there are any points that we haven't covered. We're looking at going for around about an hour. So there's probably looking at probably 20 minutes, half an hour to discussion that we've pre-prepared for you. And then the rest of the time in questions. So we'll make as much use of Paul's time and expertise as we can. Disclaimer before we start, Paul?
Yep, so obviously everything that we are covering today is very general advice. It's not tailored to any particular person. You shouldn't rely upon it before acting without getting your own independent legal advice. I think that covers it.
Thank you. So yeah, we do have to have disclaimer before we start. So, Paul, kicking off, what is GDPR?
So the GDPR is the new regulation that's coming in from the European community, and the GDPR is effectively a new regulation covering how privacy is going to be handled.
Okay.
So we're talking about what happens to people's information, what can businesses and individuals do with it, what rights do you have across all forms of business, all forms of information processing, where it touches people in the EU.
Yeah, and this has actually been, I was looking at the background and process yesterday. It has been quite a long time coming in. Do you have any insight as to why it's come about?
So I think Europe's actually been on the forefront of privacy for a long time. So we had the European Court about 5 years ago coming out and saying that people have the right to be forgotten, so you can have yourself wiped off of Google if you're in the EU. I think that this is really a reaction to a lot of the scandals that have happened with data breaches, not necessarily to the Cambridge Analytica, although that obviously comes into sharp focus.
Example.
Yeah, but over time we've seen more and more personal information getting placed online. People are being a lot more blasé with their personal information and how it's used. And so this is really a reaction to that, to try and, I guess, rewrite the balance between people's convenience and their ability to have their personal information protected.
Even though I work in the space, I actually wholeheartedly agree with all of this as well, so I'm finding it really fascinating. So who does it actually apply to? Obviously, it's come about from the European Union, but it's potentially affecting the entire world.
It is. So the way that the ordinance is written is that it says that if you're in the EU, you're caught. So that's pretty basic. But if you are an organization which is offering services or marketing things to people who are in the EU, doesn't have to be an EU resident, it could be someone holidaying over there, or if you are monitoring the behavior of people who are in the EU, then you are caught by this. There is the question about, well, if I'm caught, is anyone really going to do anything about it? Yes. Because at the end of the day, they can't sue you here in Australia, they'd have to sue you over in the EU. But I guess the question is, do you want to take that risk?
Yes. And what are the penalties for non-compliance?
It can be up to, from memory, 20 million euros. Yeah.
I recently was like 4% or
4% of your global revenue, or 20 million euro, whichever is higher. So it's not one of the ones where it's going to go down a little bit, but it's ridiculously high penalties. I mean, in Australia, by way of comparison, for our privacy laws, the penalties are $380,000 for an individual, or $1.7 million for a corporation per breach. Yeah, which to my mind is quite very high.
Quickly, yeah.
But this is just another order of magnitude.
So it is something that we do need to take very, very seriously.
Absolutely, absolutely.
Yeah. So we have talked about how this is protection of people's personal data. So what kind of constitutes personal data? What has the GDPR outlined?
So it's actually quite similar to Australia, and unfortunately, whilst I've memorised the Australian definition, I haven't quite memorised the GDPR one.
We can flick through the huge.
Yeah, I've got. If anyone's interested, I've got the whole tome here.
We will actually be sharing some links to these resources after this session, and the recording will be available afterwards, along with a short summary as well. So if you don't have a chance to watch all of this, it will be available afterwards.
So personal information, I can tell you it's Article 4 of the GDPR. It's basically any information about an individual whose identity is clear or whose identity can be reasonably ascertained. That's what it comes down to. And information is very broad. It's basically anything from which I can figure out that I'm talking about Paul Gordon from Adelaide. It could be my image, it could be my IP address, my driver's license, any of those kinds of things, just a comment describing who I am. So someone talking about a lawyer who lives in Adelaide, works in social media, is in his early 30s.
Obviously, that's you.
Well, clearly. It narrows it down quite substantially.
Yeah.
And so with that in mind, it's basically anything that has an identifying character.
What I actually found quite interesting from what I've read through as well is it even applies to having a single email address that includes a name as part of it. So email addresses that are admin at or info at or those type of generic terms are not considered personally identifiable, but even, I'm just saying, I don't even know if this is your real, just let's say Paul at NDA Law. Again, that would be another factor that somebody could identify as being you, even if the only piece of information they had was your email address.
Correct. And even in that instance where it's only my first name, it's because it is reasonable to ascertain who I am. I was like, okay, so his name's Paul, he's from NDA Law, so let's do a quick Google and there the information is.
Yeah.
So it is very broad.
So there seems to be a couple of factors here. It's obviously getting the consent, the explicit consent, to use that personally identifiable information, and then presumably the correct management of it, which would come under Australian privacy law as well, that you need to correctly care for the data that is in your possession. But then what you touched on is the opportunity to be forgotten and have your information erased as well.
Correct. And it's actually a lot more stringent than Australian privacy laws, because Australian privacy laws will only apply to businesses that are dealing in health information. So if you're a gym or a doctor or a physio, then you're caught, or if you have a turnover of more than $3 million a year. Now, if you're a smaller business, the Australian privacy laws don't apply to you. And you can basically do what you want, which is a huge gap in my opinion. But now, with the GDPR, the obligation is on everyone who is intentionally or not dealing with EU residents and people who are transiting through the EU.
I think it's actually a really good opportunity for all individuals and businesses personally to review what data they are capturing, how they're managing it, what tools they're using, and those types of things. It feels like it's come about really suddenly in some ways, even though it's been a long time coming through the EU, but it is very timely. I think something that we all need to consider regardless of this regulation. And obviously you don't know the exact answer to this, but do you have any opinion on whether we would see a similar type of regulation apply specifically within Australia or start to grow around the world in the future? This is a big crystal ball.
It is. I think that Australia has been very slow to move on privacy. So, for example, the Privacy Act came in back in the 80s, and it was only properly updated in 2014. And even then, it left us with this gaping hole of organisations who it doesn't apply to. And then when we got into the mandatory data breach notification, so that's if something goes wrong, someone hacks into your data, you have to inform the Privacy Commissioner and people who are affected. That only came in this year, in February. So it took 4 years after the original amendments to then bring in the data breach notification. So I think Australia is quite a bit behind. Whether or not things like Cambridge Analytica are going to encourage lawmakers to think a bit more quickly about it, and whether the GDPR and its impact is going to be that Australia looks to follow suit, I don't know. It's really interesting, though, because part of the issues that you have with GDPR is that if you're taking information from one jurisdiction to another, you need to be able to offer similar levels of privacy protection. Under Australian law, you can't automatically assume that.
Oh.
So if you're bringing information from the EU into Australia, there aren't the automatic protections under legislation that would apply elsewhere. Because under the GDPR, you have to have consent.
Yeah.
Under Australian privacy laws, you only have to have consent for sensitive information.
Yeah.
Everything else, the only obligation is that you need to tell people that you're collecting it.
Yeah.
Which is a reasonable obligation.
It is.
But there's not that additional element of consent required.
No. Oh, I honestly wish this was a global thing, because what's concerned me is it's the World Wide Web. It's global. We're dealing with global platforms here, even though our business, which is what we're going to talk about, you might have a business that's focused within Australia or even within South Australia, but simply by having a website, it's open to the whole world. And to have these different regulations and being trying to understand how they can affect you in different areas is really quite confusing.
It is, and it's a problem with laws in general. So intellectual property laws, so copyright and things like that, which we find is another area that comes up on social all the time, was created to be geographically based. So if I've got a license to use IP here in Australia, that doesn't help me in the US or the UK. This is another example where if you have privacy compliance here in Australia, it doesn't help you with compliance in the US or the UK or China or wherever.
It's a very difficult time. Probably going to keep you very busy as well.
There are some benefits.
The other thing I just wanted to touch on, which I've come across in my research, which people may not be aware of, there's the two different components, the two main components that apply to the GDPR, which is the data processors and the data controllers. And the data processors are organisations and platforms that help facilitate and collect data. So Facebook, Google, Instagram, Twitter, etc. are data processors. But those of us who tap into and use those services and use the data that we collect within those services are the data controllers. And there are obligations on both aspects under these regulations, aren't there?
That's right. That's absolutely right. So both the processor and the controller have an obligation, and you can't just assume that because the processor has done the right thing that you're automatically going to be covered in your use of the data, because the processor needs to obtain consent to process the data, to collect it, but you also need consent to then capture that data if you're going to take it out of what the processor has got authority for. So it comes down to that consent thing. So if someone has consented to, let's use Facebook as an example, so given Facebook permission to process your data, the next question is going to be looking at, well, what happens if I take that data out of Facebook and reuse it elsewhere?
Yeah, so that makes it more confusing as well. We've got a question from Rubina. Hi, Rubina. Asking what constitutes sensitive information.
So sensitive information, which is dealt with differently under, well, I can answer you both in Australia and the EU, because it's actually pretty much the same. It's any information that is about someone's health, about someone's religion, trade union membership, criminal history, sexuality, what was the other one? Credit history is another one, which is quite considered to be part of sensitive information. The list of the types of information is an inclusive list. So it doesn't say that that's it, that those are the only categories, but those are the examples that are given of what constitutes sensitive information. And with the GDPR, it is incredibly important to know whether you're collecting sensitive information, because one of the obligations, and this is really the hardest obligation for an Australian business to deal with, is there's an obligation if you are collecting or monitoring information on a large scale or systematically, or if you're collecting sensitive information, to have a person in the EU to handle complaints. If you're just gathering general information and it's not really what you do, it's not large scale, things like that, then you don't need to worry about that obligation. But if it is sensitive information, then you have an obligation to have a person on the ground in the EU to take complaints. So I'm assuming that there's going to be a little bit of a cottage industry opening up of people who are offering to be your privacy officer in the EU. So
it'll be like freelancer.com for privacy.
Exactly. So I'm going to be moving to Luxembourg and just setting up as a privacy officer.
That sounds like a very good career move. Not for us though. So Yeah, so thanks for that information, particularly about the data processors versus controllers, because I've been getting so many emails over the last couple of weeks from all of the different systems that I use that they've updated their statements or they're updating their systems. But it's not just a case of, like you said, assuming that they're doing the right thing and everything is still fine, because I've been reading through some of mine, and in a couple of instances, and I'll go into some examples, some systems are providing new tracking code, or there's agreements that you need to make between yourself and the processor.
Yes.
I'm trying to remember what that was called now. I had this written down somewhere. Data processing agreements that may actually be required between the controller and the processor for that understanding. So it's not just a case of ignoring these emails that are coming through, it's going through and looking at what systems you are using,
Absolutely.
What have they done, what information are you gathering, how are they managing it, and all the rest.
It underscores the importance of that data audit that you need to do, because we very much, I think, just do the work and we gather the data without really systematically going through where is this coming from, whose information is it, what agreements do I have in place that entitle me to access this data. And under Australian laws at the moment, assuming there aren't many $3 million turnover organisations listening in, although if there are, I'll leave my business card at the end. You didn't have to worry about it, but now you do.
Yeah. We will be wrapping up with a list of recommendations for what businesses should be considering. As Paul said at the start, you do need to get advice for your specific situation, but this will be a list of what I'm doing as an individual as well, because this applies to me as a business who is not actively operating in the EU, doesn't have that huge turnover, isn't actually collecting sensitive information, but am affected from a number of these areas. So the main ones that I wanted to chat through, and do send questions through, and you will keep us up to date with that. Just looking at the implications we have for websites, email marketing, social media marketing, and online advertising and remarketing, because they're 4 areas that I think affect a lot of businesses who are operating even within Australia. So your website and Google Analytics to start with. I've been doing a lot of research in this area because obviously it's a space that I work in, but the 3 main areas that I've seen that are impacted, that most users will be impacted with Google Analytics, are to do with data retention. So if you're not aware, Google Analytics has actually brought in a new feature, data retention, where they will actually forget user-specific data after a certain period of time. There's a new banner ad up at the top of your screen that you have to click on to log into Google Analytics and click on to acknowledge your understanding and acceptance of this update under GDPR. So you can still continue to collect this information. It's for 14, 26 months or 60 months, I think it is. I should know those off by heart now. Or there is still an option to never forget user information, which is interesting they've left it in, because that does actually contravene the regulation. So the recommendation is actually to, by default, Google Analytics will set that to 26 months for you. You can opt to make it sooner, or there's a longer version, which is about 54 or 60 months as well. So that's one of the big changes that they've made. It won't actually affect the general non-personally identifiable data, such as number of users, number of sessions, those types of things. It's more going to be forgetting the information about specific location and any user ID factors. So it'll affect things like user flow report. For most businesses, it shouldn't affect it, because if you they're the type of reports that you usually look at within a more recent period, rather than going back over 2, 3, 4 years. So that's one of the updates for Google Analytics.
It's really important, because one of the obligations under the GDPR is that once you no longer need the information, you are meant to delete it. So if you're just holding on to it in case, that's not good enough.
And that's regardless of somebody coming to you personally and going, I want you to forget my information. This is all information. There needs to be some period of time where you remove that. So some process that is in place. Great. The other 2 points are to do with user ID. So with Google Analytics, you can actually set up and use the user ID to collect more custom information, which may be personally identifiable. So it might be, if you have an e-commerce store, for example, it might be pulling in address details, name, phone number, those types of details, if it's been set up that way. So this is one of the areas where it's going to affect certain sites that have been set up to use Google Analytics in that way, because you shouldn't actually be having any personally identifiable information in those reports. So obviously, as a business, if your people are making purchases online, you need that information to process the order, send them what they do, but that information shouldn't be stored within Google Analytics. So that's another one of the specific Google Analytics updates. And the other one is to do with location, which is interesting because, like you mentioned, location can be related to IP address, and some of Google Analytics location tracking is done by IP address. Even though it's not something we often look at specifically, it's something that they're using.
Yes.
And there is a setting within Google Analytics that you can turn off tracking by IP address, and it will use the ISP rather than the specific IP address. So that's another setting to look at, for people to look at within Google Analytics. Are you aware of anything else? Because I know we're kind of coming at this from different angles with the legal side and understanding all the regulations versus wanting to use Google Analytics legally. Are there any other instances that you see it might affect people's general use of Google Analytics?
Not so much Google Analytics, but there are things in terms of website that are really important.
Yeah, so that's what we'll move on to then.
You
can take
so with websites, part of the test that they apply is whether or not you're actually offering services or marketing things to the EU. And if you are an Australian website and you're clearly just marketing to Australians and someone in the EU happens to access your website, that doesn't get you captured. So you don't have to panic and suddenly geofence your website away from the EU. But if you are accepting payments in euros or pounds at the moment until Brexit.
About Bitcoin.
Well,
potentially.
Good question. Probably, well, could be. If you have anything in foreign languages, so in a language other than English, if you're based here in Australia, if you are marketing your services as being global or being applicable to people globally, then even though you might not be targeting the EU, you will be deemed to be offering your services to the EU and therefore will be caught by the GDPR. Okay. So what you have on your website is really important for that reason. That
could potentially affect, I think, a number of our Australian-based, even South Australian-based tourism businesses, because I know a lot of them do offer versions of their website in other languages. And while there's, particularly with South Australia, there's a big focus on marketing the state and the country to Asia. There's a couple of sites I know personally that also have information in French or Italian or something as well. So they would have to consider that aspect.
Absolutely. And you can imagine that there might be websites out there, thinking councils or local government agencies who are just trying to provide information in multiple languages because of immigrants, could still be seen under these tests, which are articulated in the 750 recitals. No, there's only 179. The recitals to the GDPR, which says that if you are using a language other than that which is ordinarily spoken in your home country, that is a factor in assessing whether or not you're caught by this.
Okay, so do you have any advice for those types of businesses who may have other reasons for using a language other than English? Or
at the moment, the only thing I can think to do is either geo-blocking the EU or having a notice on the website saying that the following information is intended for Australian visitors or immigrants to Australia who might find this language more convenient. It is not intended to be an offering of services to people in the EU.
So providing those kind of disclaimers.
Yeah.
That's an area that I hadn't even thought of before, because the other aspect that I'm aware of from a website perspective is the use of cookies on websites, which is used by a number of services, and even having to do an audit. There's a lot of plugins the website uses that websites use that use cookies, or people may not even be aware that they're planting cookies, particularly like social media type plugins. There's some that most people would be aware are. So, I mean, Google Analytics does use a cookie, and we've mentioned some of the issues with Google Analytics. But if you're actually using something like Google AdWords remarketing, which places a cookie so that you may be able to advertise back to those people, those types of cookies are going to obviously have an effect on businesses.
Absolutely.
Whose websites are available globally.
Correct, because you're then definitely collecting information about people in the EU. You could argue that you're not offering things to those people and they just happen to be accessing the site, and therefore you inadvertently collect the information. You could try and get around it that way, but it's not clear on the information that we have as to whether or not that would work.
Because one of the ways that I know that affects me and also a number of the clients I work with is we do use the AdWords remarketing tag on a number of sites. So we are, and it's it's included in our privacy statement that this site uses cookies, but we don't have a banner at the top of these sites yet that is making that really clear to people or allowing them that opt-in. But with all of those, in those cases I'm thinking of specifically, when we do actually act on that remarketing, we are only remarketing back within South Australia or Australia.
Yes.
How does that work in regards to, obviously we're still collecting the data,
but you're not using the data.
But we're not using the data.
I think that realistically the issue is both ways. So it's collection and use. You can't just say, I'm not using it, I'm just collecting it. If you are deemed to fall within the categories of monitoring behavior of people within the EU, which that cookie issue
is actually monitoring,
is monitoring, or if you're offering services, you're caught. So even though you're not using it, you still fall under the GDPR and you still need consent.
So the recommendation that I've seen and have been considering from that cookie remarketing perspective is adding that banner ad to the top of our sites for those sites that do use that cookie as that soft opt-in to say, by click here to agree, or by continuing to use this site, you understand we are using cookies for remarketing purposes.
Now, the GDPR is a little bit unkind to automatic consent. They go through in a lot of detail about what constitutes consent. It's questionable whether or not if you continue to use this, you are accepting would be sufficient. I'm not saying it isn't, but there are some question marks about it.
So then is it looking at a case of if people don't accept it, they can't use the website?
To Google.
Okay. So there's going to be a lot of busy website developers in the next short time as well. So from the consent perspective, that's a really important part, because the other aspect that I've seen, particularly in regards to remarketing and remarketing based on email address, because you've got those two different types of remarketing: the cookie-based remarketing, which obviously requires that explicit consent that people understand they are opting in to use that, or people who do remarketing based on a list of email addresses that they may have collected through their forms or subscriber activity or those types of things. And what's your perspective on that type of remarketing?
The question is, has the individual who gave you their email address consented to you marketing to them in this way? It really comes down to, what are your terms and conditions when people sign up? What do they understand to be the purpose of giving you their email address? If it's to access a service and suddenly they're getting emails marketing, you need to make sure the requirement in the GDPR is that you have to have a very clear, prominent, separate statement about the fact that your information may be used for that purpose.
And what else? The other thing that I've seen about that is that it needs to be a very clear opt-in rather than opt-out, because I know it's been quite popular for a while now to have that pre-checked box, I consent to receive marketing materials, and you're relying on the person unchecking that if they don't want it. But now it does actually, like you said, need to be something that's very separate to standard terms and conditions, isn't conditional to submitting a form, making a purchase, all those types of things, that people can still do all of those things and agree to the general terms and conditions of your online store or your services, but that marketing is obviously kept separate and is optional.
Exactly. Yeah. And the other thing is you have to make sure that there's an ability to withdraw your consent, and it has to be as easy to withdraw your consent as to give it. So you can't make it yet that you have to go through 7 hoops in order to withdraw your consent. It has to be just as easy.
I wish a lot of businesses would actually implement that. I'm trying to get off a couple of mailing lists at the moment, and I don't understand why it's so hard. Okay, so there's a lot of thinking to do there. I did actually notice I was setting up some new forms on MailChimp yesterday, and they have introduced a whole new setting for GDPR that can go onto your forms, which is really great. So you can just tick do you need GDPR for this form? It'll automatically put in a disclaimer and have some checkboxes for your preferred method of contact that sits separately to any other aspect of the form. And they've got some good resources about what they're doing. So I'll include that in the resource links as well, because I know a lot of people use MailChimp, and that's obviously going to affect every email platform, but they've been quite proactive with that as well.
And they're great in that they have that requirement of double consent in any event. So they've been ahead of the curve already. Yeah,
and that's another recommendation that we're seeing is, again, just using that double opt-in for any email subscription, because it is making sure you are getting that approval from people that they are absolutely happy to get consent in that case. And another thing that I mentioned earlier is if you are using any email marketing systems, do look for any news that you get from them, either email or on their blog, or if they are making updates to their tracking codes, particularly any more email automation systems or sites that might, things like HubSpot, ActiveCampaign, GetResponse, those types of sites who are doing that combination of website monitoring and automated email activity, because I know some of them are starting to provide new tracking codes that you need to update on your site. To be honest, I'm not exactly sure how they work yet, because it's on my list of things to do. But that is an actual update that has to be made, rather than just agreeing to their new terms and continuing business as usual. And they're making a lot of those recommendations about reviewing all of the forms on your site, making sure that the consent is explicit, is separate from any other terms and conditions, is an opt-in rather than an opt-out, and using that double opt-in as well. So moving on, social media marketing. How does it affect us?
Substantially, basically. So we were talking about this just before we started, that effectively it comes down to what information you are using for your social media marketing. At the end of the day, the social media platforms, your Twitters, your Facebooks, Instagrams, etc., are the processors, so they have obligations with the individuals who are using the platforms. And those consents that they're getting are generally to allow use within the platform. So if you're playing within the platform itself, you should be generally okay. What comes to cause people grief is if you are taking information out of the platform, if you are using it for a purpose other than for what it was provided, then we get into issues. So
that could be things like if you're running an event within Facebook and exporting the guest list.
Correct.
Which would give you names, potentially email addresses, whatever data has been shared, that then, and you're taking outside and using it for other purposes.
Correct. Or even if you're just looking at who's liked your sponsored post. So anything where you are collecting information about an individual from the social media platform, that then takes you outside of any consent that's been given.
Another one that I thought of the other day is, I know it's quite popular with a lot of people to export their contact list from LinkedIn and then import it to their email marketing system and email their contacts. So again, that would be another one. Correct. And while it is an option you have within LinkedIn to export that data, you are then the data controller taking that information out and using it for another purpose that you may not have permission for, but also have to consider how you're using it as well.
Correct. So if you want to do it before the 25th.
Everyone's going to be exporting their contact list. And yeah, like I mentioned, I've been getting a lot of emails from all of the different social media platforms that I use that they've all updated their privacy policies recently. And another aspect of the GDPR that I think is a good thing is that the privacy policies they've said need to be in plain speak, need to be as simple and to understand as possible, as short as possible, so that we do understand them.
Correct. But that applies to businesses as well. So if you have a privacy statement, you need to make sure that it's really easy to read, really clear on what it covers and what is personal information. Why might we collect it? What kind of bits of information might we collect? All of those things need to be very clear and easy to understand.
So that's another thing we'll list on our recommendations, as well as actually going to be reviewing your privacy policy that should be made very clear on your website and throughout any of your other business collateral, or if you don't have one, set one up. And so online advertising and remarketing, we've kind of touched on this a bit, because if you are using, that was one of the examples we were talking about earlier, we kind of touched on with targeted advertising based on email address, because that was one area we had talked about potentially with Facebook, because you can import a list of email addresses and then target the advertising to them within Facebook based on personally identifiable information that has been sourced elsewhere.
So that comes into the same question. Did you, at the time when you collected those email addresses, have it in your contemplation and therefore in the individual's contemplation that you would be using it in this way? So you don't need to necessarily have said that we will be putting this into a Facebook marketing campaign, but you probably do need to have said that we might use this to target marketing at you in a number of ways. So it's really about that transparency, and in the GDPR's case, consent for you doing that.
One of the other resources that I'll share is Google do actually have quite a good article. I mean, they've provided it more so specifically for their AdSense and Google Display Network advertisers, but they've got a post that they recommend linking to as part of your privacy policy that outlines this is how we use, this is how online advertising and remarketing works, this is how we use it, that I think provides some of that language, and it is quite clear and easy to understand. That would be good for that as well. So on that, because obviously a lot of us have existing databases that we have collected over time, should we be going back to them now and asking for that explicit permission to use their data in that way, or filtering out any that we know are from the EU, or just requesting permission from the EU? Or is it going to be something that comes into effect from 25th of May, as in anybody we collected beforehand is fair game, but after this point we need to have these processes in place? So
the fact of collection before the 25th isn't an issue, but the retention of that information and the use of that information is.
Okay.
So from the 25th, if you still hold the information, you don't need to go back and cure past mistakes, but if you still hold information on individuals, you technically need to go to them and get their consent. It only applies to people who are conducting activities in the EU. So it doesn't have to be an EU citizen, but if you've captured information of someone who is transiting through the EU and they happen to give you their information whilst they're there, then that is something that you'd need to look at. If it is information for someone who's resident in the EU, then that's absolutely something that you would need to look into. It all depends upon where the information relates to.
Some of this is really challenging as well, because I know just from, I have a global email subscriber list for my blog updates, and I know they come from all over the world, but I don't always know exactly where they come from because I don't ask for that. Like, all I ask for is an email address, and I can see in my system where the emails were opened, and I can assume where some of those people may be located, but I'm not actually tracking at the moment where those subscribers are based.
So from that perspective, what you'd look at is saying, well, which of the two tests am I going to fall into? Is it the offering of services, or is it the monitoring of information? If it's the offering of services, if you aren't targeting the EU, if you aren't targeting the globe, then you're probably okay. If you are targeting worldwide audiences and you're saying this is applicable to anyone doing this particular activity anywhere in the world, and you market it in that way, then we might have an issue. The next question is, are you monitoring? And by that I mean, are you collecting information, either automated or manually, about individuals? Potentially you've got their email address, if it's got their name in it, then yeah, you probably are.
Got so much work to do. Okay. We did have another question that came through during the week. I think you did kind of cover it slightly earlier, but Joshua Moroney sent this through earlier in the week on Facebook. And it was just regarding, we'll cover it again, requirements to register with the Information Commissioner's Office and have a representative to handle data complaints. That was an area that he's unclear about.
So in terms of registration, the GDPR actually removes the requirement of registration. So previously under the old ordinance, you were meant to register if you were collecting personal information in the EU. It didn't have as strong extraterritorial reach, so it didn't really apply to people outside of the EU. And there was a fee associated with that. That's been removed everywhere other than the UK, where in the UK you do still have to register with the ICO. It's unclear what that would mean for people outside the UK. My feeling is that you probably don't need to register with the ICO over there. In terms of having a representative over in the EU, as I said, if you aren't doing large-scale monitoring of the EU, you don't, unless you are collecting sensitive information.
Like you said, people who are working in the health, finance, the other ones.
Criminal law, trade unions, that kind of thing.
Yeah, okay. Another question that I've seen a bit online with some of the research that I've been doing and just general conversations about it is to do with the UK specifically, and obviously with Brexit coming up, what impact there may be on them if they leave the EU. Will UK still be affected? Do you have any thoughts or comments on that? Again, we don't know until it happens.
Yeah, it changes so much, and it touches on so many different areas of law because they are so interlinked. The UK has been in the EU for so long that all of these laws are going to need to be unpicked and reset. So unfortunately, we just don't know. The best practice is to assume the UK will continue to be covered by this for the foreseeable future because Brexit's not going to happen next week. And until then, you're still obligated to follow the EU laws. It's after that happens that we just don't know. And that applies to all sorts of different areas of law, including privacy.
And like I said in the first place, because this does affect, I mean, even though there is that geographic area that is predominantly affected, it is affecting the globe.
Yes.
So it is something that we really should all be taking seriously and putting some of these processes into place, which are really just best practice. Because I know, I mean, sometimes from a business we kind of freak out about, oh, we have to do all this extra work or it's so hard or we're not going to be up to target to people. But like I said, personally, I like some of these because it can be really difficult to have, get removed from a subscriber list or something like that. Or, I mean, I understand how remarketing and those types of things work, but I know a lot of people don't understand and they don't realise that they're getting tracked by cookies and why they're having certain advertisements pushed at them and those types of things.
Yeah, look, I agree. And I think that whilst we might not have the obligations in Australia at the moment, it still is, as you say, best practice. So you might be technically okay, but from a, I guess, unique selling point perspective, don't you want to be able to say that you're doing the right thing by people with respect to privacy?
Yeah, so if anyone does have any more specific questions for Paul, we do have a bit more time, so feel free to pop them in the comments and Amy will pass them on to us. Speaking of which, you're two now. So Tanya, hi Tanya. Tanya's asked in regards to LinkedIn, she doesn't export her contacts to email, but what if you only email your Australian-based contacts?
So if you're intentionally excluding the EU from it and you just do your Australian-based contacts, as long as they're not temporarily based there and you don't realise it, then you should be fine. It really does just apply to the EU residents and EU citizens if they are in the EU. Because that's the other thing. You might have people who are an EU citizen, but they happen to be living in the US, living in Australia, in which case they're not captured.
Yeah.
So it's only information or behaviours that occur in the EU.
Yeah. So that's a really important one for us to remember, because otherwise that would leave all sorts of other issues
Yes.
In regards to tracking and managing this, because I know with some of the research that I've been doing, there are sites that are looking to set up those opt-in banners, but geo-target them at the EU specifically. And we were even touching on that earlier, where there may potentially be issues for people who are using VPNs for their internet access, which might hide their location, which may then fall out of those kind of targeted messages,
Correct.
which could again leave you open to potentially collecting data unknowingly.
That's right.
Or thinking that you're covered. So I'm kind of imagining every single website we go to from May 25th being covered with all the things. Do you realise? Do you realise? Do you realise? Opt in. You just need a big one when you open your browser.
Yeah.
I think so by using the internet, you are potentially being monitored. Do you consent? Otherwise, go outside. So another question from Matthew Bennett. Any tips on changes we should be making in our data collection processes now to ensure we are protected?
So the way that I would handle that is really looking at consent. So it's really looking at making sure that when you're collecting information, people understand that you're collecting that information and that they are okay with it, which is, as I said, very different to the Australian legal position, which is that as long as you tell people, it's okay. So, and it becomes quite unwieldy, though. That's the problem, because if I'm collecting information from a social media platform in particular, if I want to be fully compliant with these ordinances and with the Australian laws, I have to say to people, hi, I'm thinking of capturing your user-generated content or even your like on my post. I'm going to use that information to do A, B, and C. I might pass it on to these people, and let me know if you're okay with that before you actually capture the information.
Wow.
Which is really unwieldy and impractical, but that's the...
Because that could, now I'm just thinking, that could potentially affect, if you're taking screenshots to use in reports or presentations that include, however many people like this post, but often it does mention the names of a couple of people. It's not just the total number of likes when you're taking that screenshot.
You've just collected personal information.
Taking information out of the platform.
Correct.
Okay. I'm using the blur tool a lot from now on. So, like I said, we've got a list of recommendations with what businesses should do to prepare. Obviously, disclaimer, you do need to consider your own specific situation and get advice as well. But these are some of the steps that I'm going to be taking personally with my own websites, clients and data use, and also for the clients whose digital marketing I manage, you're going to be looking at these steps as well as getting more specific advice as well. And these will be in our written summary. So the first thing I'm going to be looking at doing is a general data audit. So making a list of all the different tools and plugins that I'm using and going through the settings for each of those. So like I mentioned, I know one in particular, Active Campaign, has said that they now require a data processing agreement between every user and them, and they provided an example that you can download and complete, as well as a new tracking code. So there's going to be all those different systems. So for businesses looking at what tools they're using, be they social media or email marketing or online, whatever. Just generally looking at the different requirements or changes that there may be for each of those, which again, I think is a really good thing to do, because it can easily we sign up to so many systems. I think you can easily lose track of what it is you're actually using. And it's also a good point. I know that I'm going to be going through and assessing whether or not I need to use all of those systems anymore, and if there are any that I can potentially stop using, or if there's a better way, like potentially if there's a tool that can handle a couple of the processes or a couple of the steps, all those types of things. So that's something I'm looking at doing. And also looking at what data you're actually collecting as well. And this is from the research that I've been doing. It's another chance to go, look, make sure where you do have inquiry forms or forms or other types of data to capture on a website, what are you capturing, and limiting it to what is absolutely necessary.
Yeah.
So obviously for a lot of forms, and particularly with email subscription, at the very least, we need an email address. And like we've talked about, that's already personally identifiable. But there are often forms that also look for extra information like role, company, city, country, age, potentially.
Gender.
Yeah, which is all, again, falling into personally identifiable. So going through and reviewing all of the forms that are on sites and what information is being collected. And then also within those forms, looking at that explicit consent and how that information is being used. So, and it doesn't just have to be an inquiry form. It might actually be, if you have an online store, as part of that sales process, obviously there's some personally identifiable information that you need to collect for that order. But that marketing component is explicit and separate, that people are opting in. They can make their purchase, but they need to have the option to leave that box empty if they don't want to receive marketing material from you. So there's that data audit, and then also looking at how your information is actually being stored and how long you're storing it for as well, and having a certain point in time where that information is destroyed, and that understanding. Updating privacy policy. So we mentioned that as well. That's going to be something. So, and if you don't already have one, to make one. So again, that's going to have that understanding of what information you're collecting, how you're using it, and making that really clear to people. And also, like you touched on, I assume the privacy policy or contact page, or it needs to be really easy for any organisation for someone to see if they want their data to be removed, how do they do that?
Correct.
And to do that as easily as possible as well. And having that process internally for when someone does contact you and say, I want to be forgotten and be erased, that process is smooth and easy for them, but that you've got a process of going, well, I know. And again, that comes down to knowing what tools you're using.
Yeah.
If somebody asks to be forgotten, you have that process of going, is it just a case of removing them from MailChimp, or does MailChimp also sync to something else, which syncs to something else? And do we need to go through and remove their information from all of those places there? So they're the main recommendations that I've come across. We've got another couple of questions, but if you've got any other recommendations, we'll jump back onto them. So another question from Joshua Moroney. Any thoughts on enforceability in terms of foreign government enforcing their own laws on us? It seems like it could get quite messy if other countries all start doing similar things.
So we touched on this very briefly at the beginning, but it will, of course, be difficult for a foreign government or a foreign government agency to take action against an organisation, though we're seeing at the moment that the EU is looking at what they do about Cambridge Analytica, and they're looking at what they do about Facebook. Australia's Information Commissioner has been asked to look into what's happening with Facebook. So where there is a public appetite, it's possible. So what would happen is that you would have a investigation, a case in the EU, for example, and then it would be a question of how is that enforced. Now, then we get into the joys of private international law and public international law and how all of those systems work, which we don't have time to go through now. But the answer is it would be very difficult, but it also would make it very hard for you to go on holiday to Paris. Because if you enter the country, then there could be an enforcement order against you. So the answer is really, yeah, it would be hard, but do you want to take that risk?
Yeah. Which I think is a lot of aspects of law, to be honest, and particularly online law from discussions we've had previously. Not to go into the whole copyright, but that's one question that people often come up with is, what are the chances?
Yeah.
And, there are cases, where the chances are quite small, but it does happen and the penalties are quite high. So
Correct.
It does need to be taken seriously. And a question from Sarah Humphreys. The Australian Privacy Act has some exemptions for small business. Do you know if this is the same for GDPR? And Tanya's asked along a similar vein, are there any exceptions? For example, not-for-profit and charitable organisations, are they exempted?
So there's no clear exemption. There are elements which, as I said before, in terms of having someone on the ground there, if you're not doing it on a large scale, then you don't need to worry about those obligations unless it's with sensitive information. but there, as far as I've seen within the documentation, there isn't anything that would exclude a not-for-profit or a charity. There's nothing that would exclude a small business, unlike the Australian laws, where you're absolutely right. The $3 million threshold applies unless you are dealing in health information or if you're selling your business and you're selling a client list.
And like you said earlier, even with that example of, council-based websites that might be providing information in multiple languages that then could come under scrutiny as to whether or not they're looking at providing services, I imagine that might occur with, or be a similar type situation with a lot of non-profits as well who may, or certain charity organisations who may provide multilingual website access. Absolutely. That then could be seen as trying to target a wider global audience that need to consider or make it really clear that they're providing this information for Australian-based residents who may find it easier.
Correct.
So it is something that all organisations, public, private, non-profit, are going to need to take into consideration. Yes. Do you have any other recommendations for businesses to prepare?
I think that firstly, don't panic would be
a good one to start with.
The best thing, because whilst this is coming in, the risks aren't high. And if you're realistically, we see with privacy in general, if you're attempting to do the right thing, if you're taking reasonable steps, even though you might not be compliant 100% with the letter of the regulation or the law, the penalties are generally more educative rather than punitive. So they're trying to teach people, not punish them.
Yeah.
So I think take reasonable steps to review your privacy policy, try and get consent where you can. You don't necessarily need to get the outpost in the EU just yet, but I think that it probably is a good idea to review your data and just understand what you're doing rather than just doing it, and have a clear plan for how you're going to handle people's information.
Yeah, I think, and like we've touched on a few times, it's while we are talking about that geographic area that is predominantly affected, a lot of this comes down to best practice.
Absolutely.
And best practice for privacy, best practice for data, best practice for general communication with your audience, regardless of where they are, making it really clear. Like you said, it's come about because people are becoming aware of how much information they are sharing, and that is occurring globally, not just within that area. It's
Correct.
It's the EU that has taken these steps before other parts of the world. So yeah, if we do have any more questions, we've probably got a couple more minutes with Paul. So thanks very much, Amy, for helping us out behind the scenes, and everyone for joining in today. And thank you very much, Paul Gordon from NDA Law. You are very, very selfless with your time and expertise here. If anyone does have any more questions or would like some specific information about their situation, then they can obviously get in touch with you, or if they have their own lawyer. It's certainly something to take seriously. Like you said, the enforceability, while that may be difficult, we do need to be looking at taking reasonable steps to take care of the data that people are entrusting to us and that we do actually have access to, because it is, with great data comes great responsibility. So thanks very much, everyone. Like I mentioned, this recording will be available on the Scout Facebook page and on the Scout website, hopefully later on today, if not tomorrow. So keep an eye out for that. We'll also be putting together a short written summary of the key points that we've talked through, if you do want to share them with anyone else in your organisation, including those steps that we're recommending organisations take to prepare for, like you said, not just for the deadline, but just begin to take these reasonable steps to be shown to be doing the right thing. So yeah, if there's no more questions, we'll leave it at that for now, almost right on time. Like I said, thank you, everyone. I know there have been lots of discussions about this in the different groups that we're a part of. So it's great to be able to actually voice and talk about these situations, because there is a lot of fear, I know, in a few areas about what's going on. So yeah, that's all from me. Thanks very much, Paul.
Thank you so much for having me.
You're very welcome. Thanks.